Good day, everybody. This is Michael Levitis from JurisQ. We give you different attorneys, different practice areas, various states and cities across US. And today we have a special guest, a personal injury attorney in Dayton, Ohio, Kevin Attkisson. Kevin, welcome back to us.
Hi, Michael. Thank you very much. Great to be with you.
Thank you for sharing your expertise, because you have been practicing law, personal injury, for more than 25 years. I'm sorry for giving away your age a little bit, but you are super seasoned, super experienced, and that's why we turn to you to educate our viewers on personal injury in Ohio.
Yes.
And Kevin, very important question today. Not too many people know this, but there are different people, different companies, different defendants that you can sue after a car accident. You can even sue your own driver, possibly if you're a passenger. You're going to talk about that, I'm sure. We're going to find out, interestingly, can you sue your own spouse? Let's talk about that as well. Let's educate our viewers. What do you say, Kevin?
Okay. Well, thank you very much. And yes. If somebody's injured in a car accident, we do need to explore all the potential defendants. Okay. So first and foremost, if you were a victim of another driver's negligence, that is, another driver has caused a motor vehicle collision and you've suffered injuries, then first and foremost, the defendant is the actual driver of the other car who was at fault for the accident. So that's our main defendant. And then there are obviously there are other potential defendants as well. If the at-fault driver was on the job at the time, they're working for a company, they're driving a truck, they're a delivery driver or whatever, then you can hold the employer responsible as well. It's the theory in the law that we call respondeat superior, and that essentially means that the employer is liable for the negligent acts of their employee while the employee is acting in the course and scope of their employment. So if they're on the job, they're working at the time, they act negligently, they hurt you, and I guess in this case, in a motor vehicle accident, then you sue the actual driver of the vehicle who caused the wreck, and you can sue the employer as well under the theory of respondeat superior. Another area of the law where there could be another potential defendant would be the theory of the law that we call negligent entrustment. Okay. That is the owner of the vehicle, not necessarily the employer, but if somebody borrows somebody else's car and that person is an incompetent driver or intoxicated or whatever, and you loan your car to that person knowing that they are intoxicated or incompetent, then that could be that the owner of the car could be held liable for entrusting their car to an incompetent driver. It's what we call negligent entrustment. So that's another potential defendant as well. Another potential defendant could be what we call a dram shop act. If a restaurant or a bar overserves a noticeably intoxicated person and then continues to serve that person, and then that person goes and drives and gets into a wreck, then the bar owner could be held liable under that theory as well. Finally, if you're in a motor vehicle accident, your own insurance company can become a defendant. Now, the at-fault insurance, liability insurance, is not a defendant. You sue the actual driver themselves, and then their liability insurance company comes in and defends and indemnifies that person. So you don't sue their actual insurance company, you sue the actual at-fault driver, but you can make your own insurance company a party. Let's say that the at-fault driver has low insurance limits. You could include your own insurance company as a party to the lawsuit and allege that they owe underinsured motorist coverage that you should have on your policy, underinsured motorist coverage for the amount of damages you suffered that is in excess of the liability coverage of the at-fault driver's insurance policy. So your own insurance company can be a defendant as well for underinsured or, in fact, uninsured motorist coverage. So those are some of the main defendants that you can have in a lawsuit when it comes to a personal injury case involving a motor vehicle accident.
Kevin, thank you for such a great overview. But this just led me to a number of follow-up questions. and I'm not sure if we can address all of them today. We should do a separate session maybe on each one. For example, I thought about Uber Eats, for example. Are you gonna, if you were injured in a collision with an Uber Eats driver, are you suing the person individually, or are you suing Uber the company, or are you suing them both? That's an interesting concept, right? And maybe we can talk about it now or at a different time.
No, we can certainly do that. Again, it goes back to the person behind the wheel is going to be your main defendant. First and foremost, it's going to be the driver of DoorDash or Uber Eats or whoever it is. Now, if you're a passenger in an Uber, obviously, and they get into a wreck and the Uber driver is at fault, then obviously that driver can be held liable too. Now, the way most of these I guess what they call gig employers are set up, they are not technically an employer for the theory of what we talked about before, respondeat superior. These are contract workers. They are independent contractors, and it's not necessarily an employee-employer relationship. But I will tell you that Uber and these other rideshare companies and the food deliveries, most of them have their own insurance. So there is insurance coverage in place that they provide the drivers while the drivers are working. So there's usually plenty of insurance coverage for Uber and DoorDash and all that. So you would sue the actual driver himself, and not necessarily Uber, because again, at least the way that things are set up right now, they're not considered employees. So you couldn't sue them theory of respondeat superior.
Okay, thank you for clearing that up. What about what I asked in the beginning, which is a very sensitive topic, I guess. If your spouse was negligent and you were a passenger, can you sue your own spouse in Ohio?
Okay, you can, but where you're going to run into trouble is that most likely you're both on the same insurance policy, and therefore you can't make a liability claim against your own insurance policy. In fact, you can't even make an uninsured motorist claim for. So you would run into issues with insurance coverage if you're married and you're both on the same policy. So that's where you're going to run into with that issue. But if it's just maybe a boyfriend girlfriend and one of them's driving and that person's at fault, then clearly you can make it. If just in general, if you're a passenger and the driver of the vehicle, you're in acts negligently and causes a wreck, clearly you can make a claim against them, and you can make a liability claim against their insurance company.
Very good. Okay, very interesting. Thank you again for educating us, for giving us such an overview of possible defendants whom you can sue after a vehicle accident in Ohio. And next time, we're going to talk about what you can sue for, meaning what you can get compensation for your pain and suffering. How do you define pain and suffering, right? Maybe lost wages, damages to your car. We're going to talk about all that in our next session. For now, I urge you, if you have any specific questions on your case, on your accident, maybe you want a second opinion from an attorney, we urge you to call the personal injury attorney in Dayton, Ohio and surrounding areas, Kevin Attkisson. The phone number is on the bottom of the screen. Thank you, Kevin. Thank you, everybody. Until next time. Take care.
Thanks.
Thanks.